American with Disabilities Act of 1990, Wendy Shade and Rick Crawford. It said throughout time, people with disability have suffered with discrimination. According to Noah Hollingbeck, it said the American with Disabilities Act of 1990 defined disability as a physical or mental impairment that substantially limits one or more major activities. A record of having such an impairment or being regarded as having such impairment can include epilepsy, blindness, deafness, paralyzed, heart disease, among a few. It falls under the federal legislation dealing with discrimination compliance with the EEOC, Equal Employment Opportunity Commission. It is believed that the ADA grew from the Civil Rights Movement of 1960, including the Title VII of the Civil Rights Act of 1964, which protected African Americans from discrimination, and the Vocational Rehabilitation Act of 1973, which protects individuals with disability from employment discrimination. The American with Disabilities Act of 1990 was signed by President George H.W. Bush on July the 26th of 1990. In 2008, the United States government revised the ADA, and on June the 1st, 2009, the American with Disabilities Act, Amendment Act, which broadened the scope of who is considered to be an individual with a disability. The main purpose of the ADA is to provide a clear and comprehensive national mandate for the elimination of discrimination and to change policies and procedures that have a discriminatory effect on individuals with disability. It also ensures that the federal government enforces all standards. The 5 major titles is Title I, Employment; Title II, Public Service and Transportation; Title III, Public Accommodation; Title IV, Telecommunication; Title V, Miscellaneous Privileges.
The ADA and Human Resource Management. It's vital for the HRM, Human Resource Manager, to be knowledgeable with all EEO legislation, including the ADA. The primary concern of ADA from the employer perspective is reasonable accommodation. Some examples include, but are not limited to, modified duties, part-time work, assistive devices, and accessibility to facilities. The ADA, however, does not require hiring of individuals with disabilities that prevent job accomplishment, nor does it require reasonable accommodations that cause undue hardship on the employer. Many grievances by employees have been filed recently on the grounds of lack of reasonable accommodation, including a record-setting $6.2 million class action lawsuit against Sears and Roebuck Company in 2009. The EEOC claimed that Sears was using an unfair labor practice towards employees who were receiving workmen's compensation benefits due to injuries received while on the job. Along with the payment of settlement monies, Sears changed their policy. Sears employees are now allowed to request reasonable accommodation when nearing the end of their workmen's compensation leave benefit time, and Sears provides them examples of reasonable accommodations that may be available. This case and many like it are being filed nearly daily. For the small business HRM, it may be even more vital to understand the ADA and even more challenging than for large companies. Small businesses generally have fewer employees, and therefore employee impact on the company is conceivably greater, as is employee absenteeism or the inability to perform duties to a maximum level. For this reason, small businesses with more than 15 employees need to be completely familiar with HRM, starting with their hiring practices. The definition by ADA for hiring is qualified individuals with or without reasonable accommodation can perform the essential functions of the job that he or she is applying for. An employer should determine the essential functions of a particular position and write them down before advertising or interviewing for the position. A determination of essential functions after a disabled applicant has been rejected will carry less weight with the EEOC and/or court systems. In summary, the Americans with Disabilities Act of 1990 has improved the treatment of individuals with disabilities tremendously. ADA is a vast-reaching law that attempts to improve housing, transportation, public services, and employment practices to all individuals with disabilities. For the human resource manager of both large and small businesses, ADA creates challenges such as reasonable accommodation that could be costly to employers. For these reasons, a wise HRM will gain as much information as possible about ADA.